Because we are looking at his humble face before he's with a pen in his mouth, I'm going to suggest that the commission call up case number 2020-S-002, the case against Anthony Nino Vitale, brought by the Secretary of State's office. That way we can just deal with Mr. Bry on two separate occasions here. That is a referral that has been submitted by the Secretary of State's office alleging various violations of Ohio campaign finance law. Along with the complaint, you received the response that Mr. Vitale submitted to the commission. At this point, I would recommend, my basic recommendation is to find a violation, because at least the campaign finance report was not timely filed. That was at issue here. It was filed one day late. I have some concerns as it relates to some of the other circumstances that have been laid out in the response and in the complaint, but I'll let Mr. Bry respond generally first, and then I may have some additional questions. The commission members may have additional questions. So Mr. Bry, please go ahead.
Thank you, Mr. Chairman, members of the commission. I'm here on behalf of respondents Nino Vitale and friends to elect Nino Vitale. The referral from the Secretary of State's office contains 6 separate counts. Only the last one relates to Nino Vitale individually. First of all, the referral is improper under, I believe the affidavit has the wrong site, but it's Revised Code 351711B3A, which states that if a statement filed with the Secretary of State is found to be incomplete or inaccurate, it, quote, shall be accepted on a conditional basis, and the person who filed it shall be notified by certified mail as to the incomplete or inaccurate nature of the statement. And later on it says, and the recipient shall file an addendum, amendment, or other correction to the statement, provide the information necessary to complete or correct the statement, end quote. Now, that wasn't done here. Obviously, at least counts 2 through 6 are claiming that there was something incomplete or inaccurate about the filings. But we had a right. Shall is not may. Shall is mandatory. The Secretary of State has a duty to do that whenever the Secretary of State finds a report appears to be, and he says this appears to be, he doesn't necessarily say it is, incomplete or inaccurate. And that's so that we can, as a filer, give the information to the Secretary of State, make the explanations so that things are sufficiently clear. Was there a violation or wasn't there? Was there a misunderstanding? And narrow down at the Secretary of State level before he ever sends anything over here, what's really in front of you and what's not. And that leads us into the second broad problem about this complaint. The rules of this commission, Ohio Administrative Code 3517-1-02A2E, talks about 2 different types of complaints. One is by individuals who do everything under affidavit. The other is by the Secretary of State, who doesn't have to do everything by affidavit, but he is required to, quote, clearly set forth sufficient facts supported by affidavits, exhibits, and or other documents to constitute a prima facie violation of Ohio election law, end quote, with references to the appropriate statute. In other words, all of the elements of a claimed violation have to be supported by documents, affidavits, exhibits, and the standard is constitute a prima facie case. The standard is not maybe something happened, or it could be, or it appears there might be a problem. The standard is, have you made all of the elements, at least in a prima facie way, necessary to support the violations that you are claiming. Now, I would like to go through each of the 6 counts separately, even though it appears that 3 of them are sort of conflated in the complaint. First count alleges the campaign committee filed its post-primary report 1 day late. It was due on June 5, 2020, and it was filed at 10:46 a.m. the next day, on June 6, 2020. We're not disputing those facts. That's when the Secretary of State got it. That's what was made public, and the due date was 4 p.m. the prior day. This was a mistake, as explained in the affidavit. He had made all the changes. You can make changes online without posting them publicly. And he made all the changes the night before. He pushed a button that he thought was going to post it publicly, and that didn't happen. He checked the next day and found that there was not a public posting. therefore he had to do the proper public posting the next morning. We think that under these circumstances, if there should be a no finding, but even if there's a finding, it's certainly something for which there should be good cause not to fine and refer. The next three all deal with claims that there were things that should have been reported in the campaign finance statements that were not. And in count 2 appears to be the allegation with respect to 3 Facebook videos. Now, what is the claim? The gist of the claim is, as Revised Code 351710D4 states, every expenditure in excess of $25 shall be vouched for by receipt of bills stating the purpose of the expenditures that should be filed with a statement of expenditures. But if you look through this complaint, the Secretary of State's referral doesn't claim and doesn't attach any documents showing that any of these Facebook videos were in excess of $25. Instead, he says each of the Facebook videos were in an amount under $100. Now, under $100 may give the feeling, well, it must have been close to that, but they weren't. And he doesn't say that. You know, they were also under $1 million. All right. You know, the fact of the matter is there's nothing in the complaint establishing that they were over $25. We filed an affidavit that says that they weren't. And in fact, what had been, they were reported, but they were reported collectively. Facebook sends a bill monthly. It is reported when received, because they actually receive an invoice from Facebook. And the invoice that included these 3 items was properly reported. But so there's no prima facie case, and it didn't happen. Secondly, and there are, I think, 3 counts that deal with. Count 3 is probably the first one that deals with the concealed carry classes that Representative Nino Vitale was teaching. And he used the same payment processor that's used for his campaign. And how that works is the payment processor takes a percentage of the money that goes into the payment processor, then transfers the funds into the campaign committee's bank account. And then when the class is done and it's too late to ask for your money back, the money is swept over to the expenses or whatever it is for the campaign account. The question is, when that money went into the campaign account, was it a contribution that should have been disclosed on the campaign contribution statement? And the answer is derived from the definition in 351701C5 of what a contribution is. And 351701C5 states that contribution means, transfers of fund or anything of value, when the contribution is, quote, made, received, or used for the purpose of influencing the results of an election, end quote. The money that was given for the CCW class, concealed carry classes, was not made, received, or used for the purposes of influencing the results of the election. In fact, Appendix E to our affidavit of response shows that when they were asking people to pay for a CCW class, we use my political site to receive the money, but it will not be considered a political contribution. It wasn't considered a political contribution when made, it wasn't considered a political contribution when received, and it wasn't used to influence the results of an election. And therefore, this was not a contribution that should have been reported as a contribution to the campaign. Also, there's a vague reference in the complaint to, quote, natural expenditures, end quote, for the payment processor who processed the CCW concealed carry fees for the class. But the campaign didn't pay for that. The money that the processor received, Pyrex, comes out of money that is sent to Pyrex. And since this money was for the concealed carry class, the payment to Pyrex for taking the concealed carry money came out of the concealed carry money and did not come out of any funds of the campaign. And again, I mean, to say that there's natural expenditures is speculation. It's not a prima facie matter. Count 4. The Secretary of State speculates that we violated, or the campaign committee violated, the duty to file complete campaign finance statements because it didn't report the monthly fees for MailChimp. Well, as the affidavit says, they didn't have any monthly fees for MailChimp. Like a lot of other internet services, they're free as long as you don't use them too much. And, Nino Vitale and his campaign had been using this for, or using MailChimp for years without having to pay for it because he doesn't have enough activity to require a payment. So you don't have to report expenses that you don't have, and he didn't have any expenses for the MailChimp. That brings us to the last two counts, both of which relate to the concealed carry thing. Count 5 claims that the campaign committee violated Revised Code Section 3517-10D3A when concealed carry funds went into the campaign committee's account, and therefore they shouldn't have done that. Now, what does 3517-10D3A actually say? What it says is that, with certain exceptions, a campaign committee shall deposit 1, all monetary contributions received by the committee, which again, these were not monetary contributions because they don't meet the definition of contributions, into 2, an account separate from a personal or business account of the candidate or campaign committee. This was not a personal or business account of the candidate or campaign committee. This was a campaign account. And no money from the campaign committee was deposited into a personal or business account of the candidate or the campaign committee. Rather, that the concealed carry class funds were briefly transferred into and out of the same bank account as that used by the campaign committee, but that didn't make the campaign's bank account a personal business account. And indeed, even the complaint doesn't claim that you should not have deposited any of the campaign money into the campaign account, as they obviously did. And therefore, there's no 3517-10D3A violation. I realize that we think, well, isn't it just commingling funds? It doesn't really matter which account the money's going into. But although we speak of that generally, that's not what the statute actually says. The statute actually says not that you can't put personal business money into a campaign account, but that you can't put campaign monetary contributions into a personal business account. And that did not happen. It perhaps, if the Secretary of State believes strongly enough about this, he could encourage the legislature to change the statute. But right now, we're dealing with the statute as it is written, not as we would like it to read. And lastly, count 6, the only count that has been levied against Nino Vitale personally, which claims a violation of 3517-13-0, which prohibits a beneficiary of a campaign fund, which Nino Vitale is for his campaign committee, to convert for personal use anything of value from the beneficiary's campaign fund. Well, first of all, the concealed carry class payments were not contributions to the campaign committee, so he didn't benefit from money that belonged to the campaign committee. He also, for that matter, never personally benefited from concealed carry class payments. He donated to charity. I mean, there were some expenses that they paid, but basically anything over profit was not profit, and we've got attachments to the affidavit showing that. And as we talked about before, the campaign did not pay for the Pyrex processing of the concealed carry class payments because it went through Pyrex and it took the money from the concealed carry class payments to pay for that, not the campaign. So there is no money transferred from the campaign committee to him personally, and thus no 3517-13-0 violation. Once again, the potentially confusing nature of this case is because I think it's pretty clear from the affidavit that there weren't not any violations, at least from 2 through 5, and you can argue about the 1 day late thing, But we would like to get this over today. We don't want a hearing. We obviously want everything to be dismissed, but we think that if the Secretary of State had done what he was supposed to have done with respect to 3517-11B3A, we would have to do this, and we'd just like to get it over. I'm sorry, did I talk over someone who was asking a question?
Not to me at this point.
Okay.
I would like you to explain better how, I mean, the concerns I have are essentially the use of the campaign committee's website. Well, 2 things. Obviously, I already spoke about the late filing. The campaign committee's website, using the link that you talked about there, and I guess to that, I guess when I am simplistic in my mind, when I think of, when I see there's something that says, okay, you can make a contribution, and, click on this and make a contribution, and you use that system, that process, and the money goes into an account. So what you're telling me is that, and I appreciate what you're saying about D3. I agree that the language is kind of backwards, but at the same point, you're intermingling campaign committee assets funds potentially with non-committee assets funds. How do you keep them separate? I'd like to understand that.
Okay. Well, you've asked two different questions. First of all, the Facebook, the website is a dual-use website personally owned by Nino Vitale. He uses it for his campaign. He can use it for other things too. And he's actually, in terms of the personal use of it, has vetted that with other lawyers who are concerned about public ethics and work for the government. The bank account issue, again, we're talking about commingling funds, and we, as a shorthand, use the reference as commingling funds, but that is not what the statute says. How then do you keep them separate? It is a fair question. The way you keep them separate is you receive notice exactly of who has paid money and signed up for the class. That's part of, it's not done through the payment processor process, but it's done coextensively with that. Just as a campaign committee receives information on who donates to the campaign committee, at the same time the money itself goes to the campaign processor. The concealed carry folks receive information on who is signing up for the concealed carry classes. At the same time, their fee for that goes to the Pyrex folks, that are doing that. So they have from day one a separate tally of exactly who goes to who and who goes to what. By the way, although I'm going back a few years and really wasn't able to track down the case, there was a case in front of this commission like 25, 30 years ago in which I represented the National Rifle Association's Political Victory Fund. And the Elections Commission had found against them and fined them $1,000 a day because they had a single bank account, which they separated out administratively into state PACs for Ohio and Indiana, Wisconsin, wherever, and their federal PAC. But it was all one fund, and they only reported the money that on their books was dedicated and legal in whatever state they were dealing with. Ultimately, the Franklin County Court of Appeals overruled that and said that was proper under Ohio law, and apparently under I can't remember whether they had other issues for that, but they did find that it was proper. So that is how we kept track of things separately. Yes, it did. Your money that was not campaign money did go into the campaign's account. And a reading at 351710D3A does not prohibit that.
Commission members have any questions?
Yeah, Mr. Bray, on the affidavit filed by Mr. Vitale on number 36, he said, I made it very clear that these are not contributions to my campaign in talking about the CCW class.
Right.
First, how are these CCW classes advertised, and how did he make it very clear that these monies are not to be used for his campaign?
Well, to answer the second question first, if you would take a look at page 9 of the affidavit, which is the image from the electronic sign up form that is public, it clearly states, quote, we use my political site to receive the money, but it will not be considered a political contribution, end quote. So that's how he makes it very clear that these were not political contributions. That when people sign up on that's how that works. And your other question, I'm sorry, I forgot your other question.
Well, on number 35, it says, I think you just answered that, about the
right.
These are not.
He's making it clear. It's not
I make it very clear. The other question was, how are the classes advertised?
I don't know. I presume that they're advertised. I believe they're advertised on Facebook and otherwise. Let's see. So we've got a August 6th first. There's some attachments to the complaint that note the advertisement again on the dual use Facebook. It's his Facebook page, and he advertises for this concealed carry as well as promotes his campaign committee. I think the issue on that was, as a matter of course, they always include the statement paid for by the campaign committee on everything, rather than trying to sort out which is which. But the reality is it's a dual use. It's not exclusive to campaign committee site.
So if I'm going to contribute to this CCW class, I want to take the class. I send money or a check. Who handles that? Is it the campaign that handles my check and then diverts it to a special account? Is that how that works?
Well, the way it happens is if you're paying by check, you'd probably just send it directly to the CCW folks. It would never go through the campaign. If you pay through the fund process, in other words, if you do an online payment, there is a fund processor, I think called Pyrex, that when you click on, I want to contribute $100 to Nino Vitale's campaign, or I want to pay $50 or whatever it is to sign up for the CCW class. That money electronically goes into the fund processor. The fund processor then deducts their fee, a percentage of the money that comes in from the payment that is made, and transfers that money over into the account. And the account that they transferred into is the account that's the bank account of the campaign committee. So the money that is electronically paid for the concealed carry classes that through Pyrex Pyrex deposits them into the bank account of the campaign committee. Because the CCW classes have a list of who signed up for it, how much money each of them paid for it, they are able, once it's too late for them to say, I want my money back, they sweep the money out of that into, I don't know where they sweep it into, but they take the money out of the campaign committee and use it to pay for expenses or donations with respect to any profit.
So you can send a check directly to the CCW class and bypass the campaign entirely?
Yeah, I think you can. I mean, I'll have to take a look again at the attachments, but I would think if somebody wanted to send a check, they could. They don't have to send it to the campaign. This is just the electronic stuff that we're dealing with here.
Okay, that's all I have. Thank you.
In regard to, this is Commissioner Kaufman, in regard to that discussion, under count 3, the response, item number 36, it says very specifically, this money never goes into my campaign account, that there are separate accounts. So are there in fact 2 separate accounts that when using the Pyrex, that campaign will go into one section and then CCW goes into another? Okay.
I think that we may be parsing words here. The bank account, the money goes into the bank account, but the campaign account is the total of all contributions into the campaign out of which expenditures are made. So he keeps detailed records of anybody for the CCW class, and then when it's swept out of that bank account, it's swept into a separate account used to pay instructors. So there's no payment directly from the campaign committee's bank account to pay for instructors, other expenses, or to whatever profit is given away, I suppose.
Thank you.
Anyone else have any questions? I would ask our executive director at this time. You had indicated a recommendation. Do you want to talk about that?
Yeah, I mean, honestly, I think, to me at least, I appreciate a lot of what has been said. As usual, Mr. Bry makes a good presentation. I feel like the manner in which funds are taken by using the link to the Vote Nino Vitale website or what have you is, it's questionable, I guess. It may not be improper, but when you start calling in the campaign facilities, for want of a broad term, and making a linkage there. I just think that that could be handled better and differently when you're doing something that's not campaign related. I appreciate that there can be things that cross over, but there's such a linkage here between the Vitale website, the Elect Vitale website, and the CCW classes. I'm uncomfortable with it. Uncomfortable doesn't necessarily make me want to say it's a violation, but I go back to the fact that the report was filed late, and looking at that as a violation. My recommendation would be to find a violation there, but for good cause, not impose a fine, or refer the matter for prosecution.
Is that just as to that first violation, Phil?
That's my recommendation, yes, as to the first.
I move that we follow the executive director's recommendation as to the first violation and only the first violation.
Was that you, Ms. Kaufman, seconding?
It was.
Okay, thank you. Kind of broke
Thank
in and out. So we have a motion to find a violation, but for good cause as it relates to count 1 of the complaint. All in favor signify by saying aye. Or raising
Aye.
Aye.
All opposed? That motion passes 7-0.
I would say that I would move, this is Commissioner Arnold, move that we set the remaining counts for a hearing.
Second, Commissioner Tavares.
Set for hearing counts 2 through 6. Okay. We have a valid motion and a second for setting items 2 through 6 for a hearing. We'll try this at least. All in favor signify by saying aye or raising your hand.
Aye.
Aye.
All opposed? Hearing no opposition, that motion also passes 7-0.
Mr. Richter,
I'm sorry.
I'm sorry to interrupt. I don't know if I paid enough attention to what Commissioner Norman said. We did not impose a fine or penalty on the first count finding. Is that correct?
Correct.
Correct.
That was
Okay.
good talk.
Thank you. Thank you.
Okay. We'll work out a time for going forward on the other elements.
All right, thank you.